Judge Kevin Castel of the Southern District of New York has issued his sanctions opinion against the lawyers who turned in ChatGPT as their legal filing. It was, I think, 6 or 8 cases that were not real, and a couple of which were pretty heavily used and relied upon for the proposition that if you declare bankruptcy, it can stall your case against the airline, and then you can file your case against the airline a little bit later and get some extra time. But now there wasn't any extra time because there weren't any extra cases, and ChatGPT just made up the cases when Attorney Schwartz asked it to. He might not have realized that he was asking it to generate cases or that it could generate cases, but as you saw from my reading of the transcript, the judge really picked up on how, depending on how you ask the question, you could be asking it to create information out of whole cloth in order to support the proposition that bankruptcy tolls the statute of limitations, which is what Stephen Schwartz asked it. So let's take a look at now the sanctions ruling. That was the transcript. The judge hadn't made a decision until Friday. Now it's Sunday. You'll get this on Monday. Here's the decision. And the judge writes, in researching and drafting court submissions, good lawyers appropriately obtain assistance from junior lawyers, law students, contract lawyers, legal encyclopedias, and databases such as Westlaw and LexisNexis. Technological advances are commonplace, and there is nothing inherently improper about using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. That's Rule 11 of the Federal Rules of Civil Procedure. Peter Loduca, Stephen A. Schwartz, and the law firm of Levidow, and Oberman, the respondents, because they're not the parties, they're not plaintiffs, they're not defendants, they're the respondents to the court's order to show cause. The respondents abandoned their responsibilities when they submitted non-existent judicial opinions with fake quotes and citations created by the artificial intelligence tool ChatGPT, then continued to stand by the fake opinions after judicial orders called their existence into question. Many harms flow from the submission of fake opinions, and the court notes one happened here. The potential mischief is demonstrated by an innocent mistake made by counsel for Mr. Schwartz, so not one of the respondents, but their attorneys. And for the law firm, counsel promptly caught the mistake and corrected it on its own, but the initial version of the brief in response to the order to show cause submitted to the court included 3 of the fake cases in its table of authorities, meaning those cases somehow made it into the official table of authorities, not the table of suspect cases, or maybe not at all. The opposing party wastes time and money in exposing the deception. The court's time is taken from other important endeavors. The client may be deprived of arguments based on authentic judicial precedents. There is potential harm to the reputation of judges and courts whose names are falsely invoked as authors of the bogus opinions, and to the reputation of a party attributed with fictional conduct. It promotes cynicism about the legal profession and the American judicial system, and a future litigant may be tempted to defy a judicial ruling by disingenuously claiming doubt about its authenticity. The narrative leading to the sanctions against respondents includes the filing of the March 1st submission that first cited the fake cases. But if the matter had ended with respondents coming clean about their actions shortly after they received the defendant's, Avianca's, March 15th brief questioning the existence of the cases, or after they received the court's orders of April 11th and 12th requiring production of the cases, the record would look quite different. Instead, the individual respondents doubled down and did not begin to dribble out the truth until May 25th, after the court issued an order to show cause why one of the individual respondents ought not be sanctioned. It's better to eat crow while young and tender, or surely you will eat the crow when it is old and tough. For reasons explained, and considering the conduct of each individual respondent separately, the court finds bad faith on the part of the individual respondents based on acts of conscious avoidance and false and misleading statements to the court. Sanctions will therefore be imposed on the individual respondents, Rule 11 also provides that, absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its associate or employee. Because the court finds no exceptional circumstances, sanctions will be jointly imposed on the Levidow firm. The sanctions are limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. Set forth below are this court's findings of fact and conclusion of law. Now, we'll go over the findings of fact in a moment, but if you're eager to hear what happened to them and you didn't hear it on my previous live stream, the court imposed a $5,000 fine jointly and severally against the respondents. So that's not a lot of money, but it's enough to certainly get everyone's attention that this is a big deal. They also have to serve copies of this opinion and the ChatGPT transcript, or the hearing transcript, on the parties involved. So the client, the judges who were named in the fake opinions, if the judge is a real judge, which they are in many cases, those judges get to be notified of this too, so that everyone who's had a fake case made of them, like they get to know that this is a problem. And of course, this whole thing has blown up in the legal world. If you read any legal news whatsoever, this has been number one at the top of the list on the front page of every site, because this is a brand new technology and someone has walked right into its trap. Just like the Zoom call, or the not Zoom call with the lawyer who was not a cat. So the findings of fact. This is the judge telling the story from the beginning. Roberto Matta commenced this action on or about February 2nd, 2022, when he filed a verified or signed complaint in the Supreme Court of the State of New York, New York County, asserting that he was injured when a metal serving cart struck his left knee during a flight from El Salvador to JFK. Avianca removed the action to federal court, so from state court to federal court, February 22nd, 2022, asserting federal question jurisdiction under the Convention for the Unification of Certain Rules Relating to International Carriage Done by Air, done at Montreal, Canada, 28 May 1999. The Montreal Convention. Stephen A. Schwartz of the Levidow firm had been an attorney listed in the state court complaint. But upon removal from state court to federal court, Peter Loduca of the Levidow firm filed a notice of appearance on behalf of Matta March 31st, 2022. Mr. Schwartz is not admitted to practice in this district. Mr. Loduca has explained that because Mr. Schwartz is not admitted, Mr. Loduca filed the notice of appearance while Mr. Schwartz continued to perform all substantive legal work. So far, not a huge problem as long as Mr. Loduca is reviewing Mr. Schwartz's work. There are prohibitions against ghostwriting. There are prohibitions against filing things under someone else's name. So Mr. Loduca can file Stephen Schwartz's work, but it has to have Mr. Loduca's name on it, and he's responsible for it. And he can't misrepresent who has prepared it either. January 13th, 2023, Avianca filed a motion to dismiss, urging that Matta's claims are time-barred under the Montreal Convention. So the time has run out. On January 18th, a letter signed by Mr. Schwartz and filed by Mr. Loduca requested a 1-month extension to respond to the motion from February 3rd to March 3rd. The letter stated that the undersigned will be out of the office for a previously planned vacation and cited a need for extra time to properly respond to the extensive motion papers filed by the defendant. The court granted the request. On March 1st, Mr. Loduca filed an affirmation in opposition to the motion to dismiss. The affirmation cited and quoted from purported judicial decisions that were said to be published in the Federal Reporter, the Federal Supplement, and Westlaw. Above Mr. Loduca's signature line, the affirmation in opposition states, "I declare under penalty of perjury that the foregoing is true and correct." Although Mr. Loduca signed the affirmation in opposition and filed it on ECF, he was not its author. It was researched and written by Mr. Schwartz. Mr. Loduca reviewed the affirmation for style, stating, "I was basically looking for a flow, make sure there was nothing untoward, no large grammatical errors." Before executing the affirmation, Mr. Loduca did not review any judicial authorities cited in his affirmation. There is no claim or evidence that he made any inquiry of Mr. Schwartz as to the nature and extent of his research, or whether he found any contrary precedent. Mr. Loduca simply relied on a belief that work produced by Mr. Schwartz, a colleague of more than 25 years, would be reliable. There was no claim made by any respondent in response to the court's orders to show cause that Mr. Schwartz had prior experience with the Montreal Convention or with bankruptcy stays. Mr. Schwartz has stated that my practice has always been exclusively in state court. Respondent's memorandum of law asserts that Mr. Schwartz attempted to research a federal bankruptcy issue with which he was completely unfamiliar. Avianca filed a 5-page reply memorandum on March 15th. It included the following statement. Although plaintiff ostensibly cites to a variety of cases in opposition to this motion, the undersigned has been unable to locate most of the case law cited, and the few cases which the undersigned has been able to locate do not stand for the propositions for which they are cited. It impliedly asserted that certain cases cited in the opposition were non-existent. Plaintiff has not cited any existing authority holding that the bankruptcy code tolls the 2-year limitations period or that New York law supplies the relevant statute of limitations. It then detailed by name and citation 7 purported decisions that Avianca's counsel could not locate and set them apart with quotation marks to distinguish a non-existent case from a real one, even if cited for a proposition for which it did not stand. Despite the serious nature of Avianca's allegations, no respondent sought to withdraw the March 1st affirmation or provide any explanation to the court of how it could possibly be that a case purportedly in the Federal Reporter or Supplement could not be found. The court conducted its own search for the cases but was unable to locate multiple authorities cited in the affirmation in opposition. Mr. Loduca testified at the June 8th sanctions hearing that he received Avianca's reply submission and did not read it before he forwarded it to Mr. Schwartz. Mr. Schwartz did not alert Mr. Loduca to the contents of the reply. As it was later revealed, Mr. Schwartz had used ChatGPT, which fabricated the cited cases. Mr. Schwartz testified at the sanctions hearing that when he reviewed the reply memo, he was operating under the false perception that this website, ChatGPT, could not possibly be fabricating cases on its own. He stated, "I just was not thinking that the case could be fabricated, so I was not looking at it from that point of view." My reaction was, ChatGPT is finding that case somewhere. Maybe it's unpublished, maybe it's appealed, maybe access is difficult to get. I just never thought it could be made up. I'm pretty sure that one of the tenets of a free and open society is free and open access to its court's opinions. So how could you have like a valuable appeals court decision that you have to pay to get access to? That doesn't make any sense to me, unless I guess you're one of those people who thinks that that's the way the world should be. I'm not accusing anyone of anything, just ew. Mr. Schwartz also testified that he knew there were free sites available where a known case citation could be seen. We went over that. Then the court asked for copies of the questionable decisions: Varghese, Shaboon, Peterson, Martinez, Estate of Durkin, Earl Inree air crash disaster near New Orleans. New Orleans. April 12th, the court issued an order directing Mr. Loduca to annex an additional decision that was the Siefring versus Korean Airlines. Mr. Schwartz understood the import of the orders of April 11th and 12th. I thought the court searched for the cases and could not find them. Mr. Loduca requested an extension of time, again asking for time because he's on vacation. Mr. Loduca's statement was false because Mr. Schwartz was on vacation. Mr. Loduca executed the affidavit, and they turned in what work they could find. So they couldn't find the complete cases. They knew that they didn't have the complete cases, but they turned in what they had anyway. In fact, Mr. Loduca did not author the April 25th affidavit, had no role in its preparation, and no knowledge of whether the statements were true. Mr. Schwartz was the attorney who drafted the affidavit and compiled its exhibits. So he also signed an affidavit falsely. At the sanctions hearing, they went over how that happened. The court reviewed the purported decisions annexed to the April 25th affidavit, which have some traits that are superficially consistent with actual judicial decisions. The court need not describe every deficiency, but it makes the following examples. The Varghese decision is presented as being issued by a panel of judges for the Court of Appeals for the 11th Circuit, Judges Adalberto Jordan, Robin Rosenbaum, and Patrick Higginbotham. With the decision authored by Judge Jordan, it bears a docket number. Varghese discusses the Montreal Convention's limitations period and the purported tolling effects of an automatic bankruptcy stay. The 11th Circuit clerk confirmed the decision is not authentic, and the judge goes over the case, which we already went over it a couple times, but it starts with the wrongful death claim of George Scaria Varghese, but then it suddenly starts talking about the contract claim of Anish Varghese, who was bumped from a flight or missed a flight due to overbooking or something. The citation is incorrect. The Federal Reporter citation comes back to JDV Azar. The cases the Varghese decision cites are also false and do not exist. This is really a case study in the hallucinations of a large language model. So here we have various hallucinated cases and case citations. There is a case, Zischerman v. Korean Airlines, but it held that the Warsaw Convention does not permit a plaintiff to recover damages for loss of society resulting from the death of a relative. Nothing about a bankruptcy stay. There is a Second Circuit bankruptcy decision in re BDC 56, but it does not discuss a bankruptcy stay. In other decisions, Varghese has correct names and citations, but they do not contain the language quoted or supported. PPI Enterprises does not discuss federal bankruptcy stay, is in the wrong circuit. Begeer v. IRS does not discuss bankruptcy stay. Kaiser Steel does not discuss bankruptcy stay, etc. There's also the Miller decision, purports to apply the Warsaw Convention. The Miller decision does not exist. Peterson does not exist. Shaboon, Martinez, Durden, all do not exist. Mr. Schwartz testified that he began by querying ChatGPT for broad legal guidance and then narrowed his questions to cases that supported the argument that the federal bankruptcy stay told the limitations period for a claim under the Montreal Convention. ChatGPT generated summaries or excerpts, but not full opinions. The June 6th Schwartz Declaration annexes the history of Mr. Schwartz's prompts to ChatGPT and the chatbot's responses. His first prompt stated, "Argue that the statute of limitations is told by bankruptcy of defendant pursuant to Montreal Convention." ChatGPT responded with broad descriptions of the Montreal Convention, statute of limitations, and the federal bankruptcy stay, advised that the answer to this question depends on the laws of the country in which the lawsuit is filed, and then stated that the statute of limitations under the Montreal Convention is told by a bankruptcy filing. It is not. ChatGPT did not cite case law to support these statements. Mr. Schwartz then entered various prompts that caused ChatGPT to generate descriptions of fake cases, including provide case law in support that statute of limitations is told by bankruptcy of defendant under Montreal Convention. Show me specific holdings in federal cases where the statute of limitations was told due to bankruptcy of the airline. Show me more cases. Give me some cases where sick Montreal Convention allowed tolling of the statute of limitations due to bankruptcy. If any of you have played with ChatGPT or use it for more than playtime, it's gonna answer these questions incorrectly. Obviously, to our human brains, Mr. Schwartz is asking it for the results of legal research. Do the research and find me cases that really exist that support this proposition of the bankruptcy statute tolling the stay, tolling the statute of limitations. But instead, what he's really telling it, when you don't think like a lawyer, when you think like a programmer or a large language model user, he's really telling it, generate this for me. He's really telling it, your output should be something that matches this. It doesn't really matter to ChatGPT whether it's the source of the output is a real case or not. You asked it to write something that supports this, so it's going to just write something that supports this. And when it does its little loop thingy, its feedback loop, it's going to give you the wrong information. It's going to generate a case for you. It's not going to give you legal research. There's more complex ways to use ChatGPT to actually get legal research. I'm still trying to figure all that out myself. But yeah, the legal world is always a little bit behind on technology. So the fact that it happened isn't the bad part. It's the follow-up. It's the not eating crow while it's young and tender, not admitting your mistake the moment you knew there was a mistake. Seriously, as a lawyer, if you admit your mistake the moment you make a mistake, and then you do everything you can to correct it, nothing really bad happens. When directed to provide case law, show me specific holdings, show me more cases, and give me some cases, the chatbot complied by making them up. At the time that he prepared the affirmation, Mr. Schwartz did not have the full text of any decision generated by ChatGPT. He cited and quoted only from excerpts generated by the chatbot. In his affidavit, he stated that he relied on ChatGPT to supplement the legal research performed. He also stated that he greatly regrets having utilized generative artificial intelligence to supplement the legal research performed herein. But at the hearing, Mr. Schwartz acknowledged that ChatGPT was not supplementing his research. It was more like it was his research. Mr. Schwartz's statement that ChatGPT supplemented his research was a misleading attempt to mitigate his actions by creating the false impression that he had done other meaningful research on the issue that did not rely exclusively on the AI chatbot, when, in truth and in fact, it was the only source of his substantive arguments. These misleading statements support the court's findings of subjective bad faith. So there you go. The judge has pointed it out. That's one of the things that the judge finds bad faith, because the lawyers, they massaged the wording of the situation to make themselves look good. And look, the judge called them out on it and caught them. Following the receipt of the April 25th affirmation, the court issued an order directing Mr. Loduca to show cause why he ought not be sanctioned under the various rules. Rule 11, 1927, inherent power of the court, for the non-existent cases, for the judicial opinions, and I think eventually for the false affidavit. Mr. Schwartz made the highly dubious claim that before he saw the first order to show cause, he could still not fathom that ChatGPT could produce multiple fictitious cases. He states that when he read the order, I realized that I must have made a serious error, and there must be a major flaw with the search aspects of the ChatGPT program. The court rejects Mr. Schwartz's claim, because he acknowledges reading Avianca's brief claiming that the cases did not exist and could not be found. He concludes that the court could not locate the cases from when he read the April 11th and 12th orders, and he had looked for Varghese and could not find it, and he had been unable to locate Schiefring after the court ordered its submission. The Schwartz affidavit of May 25th contained the first acknowledgement from any respondent that the affirmation cited to and quoted from bogus cases generated by ChatGPT. The affidavit included screenshots taken from a smartphone in which Mr. Schwartz questioned ChatGPT about the reliability of its work. Is Varghese a real case? Are the other cases you provided fake? ChatGPT responded that it had supplied real authorities, and they could be found through Westlaw, LexisNexis, and the Federal Reporter, which that's a normal response. So of course, the large language model is trying to generate something that looks real, right? It's not that it thinks things are real or not. It's just mimicking what it knows and what it sees. It's source material. So yes, you can find this case on Westlaw is a normal thing you would say. So it's really interesting. If you're just thinking about legal research engines, yeah, you're going to get this wrong. But if you have any idea how ChatGPT works, it's just going to tell you what you want to hear. That's exactly what it does. When those screenshots were submitted as exhibits, Mr. Schwartz stated the citations and opinions in question were provided by ChatGPT, which also provided its legal source and assured the reliability of its content. This is an assertion by Mr. Schwartz that he was misled by ChatGPT into believing that it had provided him with actual judicial decisions. While no date is given for the queries, the declaration strongly suggests that he questioned whether Varghese was real prior to either the March 1st affirmation or the April 25th affidavit. But Mr. Schwartz's declaration of June 6th offers a different explanation and interpretation, and asserts that those same ChatGPT answers confirmed by his then growing suspicions that the chatbot has been responding without regard for the truth of the answers it was providing. Quote, before the first order to show cause, however, I still could not fathom that ChatGPT could produce multiple fictitious cases, all of which had various indicia of reliability, such as case captions, the name of the judges from the correct locations, and detailed fact patterns and legal analysis that sounded authentic. The first order to show cause caused me to have doubts. As a result, I asked ChatGPT directly whether one of the cases it cited, Varghese, was a real case. Based on what I was beginning to realize about ChatGPT, I highly suspected it was not. However, ChatGPT again responded that Varghese does indeed exist, and even told me that it was available on Westlaw and LexisNexis, contrary to what the court and defendants' counsel were saying. This confirmed my suspicion that ChatGPT was not providing accurate information and was instead simply responding to language prompts without regard for the truth of the answers it was providing. However, by this time the cases had already been cited in our opposition papers and provided by the court. These shifting and contradictory explanations, submitted even after the court raised the possibility of sanctions, undermine the credibility of Mr. Schwartz and support a finding of subjective bad faith. On May 26th, the court issued a supplemental order directing Mr. Schwartz to show cause why he ought not be sanctioned for aiding and causing the non-existent cases. So it's all the same stuff, but now including Mr. Schwartz and the Levidow firm. Counsel filed notices of appearances, and they held the sanctions hearing on June 8th. You can see my live stream on the court transcript that we obtained. At no time has any respondent written to this court seeking to withdraw the March 1st affirmation in opposition or advise the court that it may no longer rely upon it. Yeah, that's kind of an oversight that they forgot that you can do that. You can withdraw the thing you filed and say, hey, I made a mistake. Sorry, I'm going to withdraw that before anybody further acts on it. You can do that, and they should have done that. So we've already gone over a lot of these ethics rules, but we'll briefly go over them again while skipping ahead. Rule 11 is Federal Rule of Civil Procedure 11, and basically anyone, especially an attorney who signs a court paper, they are basically sticking up for it. They are putting their butt on the line that the claims, defenses, other legal contentions are warranted by existing law or non-frivolous argument, etc. A court can sanction an attorney for abuse, etc., for failing to meet any of their duties in Rule 11. There's also the rules of professional conduct. Rule 3.3 is your duty of candor and honesty to the tribunal. This is where you are required as a lawyer, as an officer of the court, like an officer of the military. The officer of the court is an official position in the court. Your position may not be to serve the judge, but you are to serve the rule of law. You are to serve the efficiency of justice, and you are an officer of that court. So you have rules that you have to follow as an officer, like the duty of honesty and candor to the tribunal. So you can't make false statements or even withhold things to try and trick the judge. No. You're part of the process. You're supposed to be helping the process, not inhibiting the process. It's a crime to knowingly forge the signature of a U.S. judge. Okay. Not sure who forged the signature of a U.S. judge. Okay. Fake opinions do not include any signature, and the court therefore concludes that they did not violate that. Okay, great. But the court does recognize the submission of fake cases as an unprecedented circumstance. A fake opinion is not existing law in citation. Citation 2, a fake opinion does not provide a non-frivolous ground for extending, modifying, or reversing existing law. So Rule 11, an attempt to persuade a court or oppose an adversary by relying on fake opinions is an abuse of the system. Even though Mr. Schwartz is not admitted to practice directly, the judge does still have the power to impose a sanction on any attorney that violated the rules regardless. The judge goes over a lot of basic due process rules, how you have to show bad faith. The judge can't just impose a $5,000 fine without explaining why and having some real good reasons to do so. So the judge goes over the bad faith standard here. That's why this is so long. So I'm going to skip ahead of all this because we want to hear more about the facts of what happened to Mr. LoDuca and Mr. Schwartz. So here's the violations. Mr. LoDuca violated Rule 11 in not reading a single case cited in his affirmation, taking no other steps to check whether any aspect of the assertions of law were warranted. An inadequate or inattentive inquiry may be unreasonable under the circumstances, but signing and filing that affirmation after making no inquiry was an act of subjective bad faith. This is especially so because Mr. Loduca knew of Mr. Schwartz's lack of familiarity with federal law, the Montreal Convention and bankruptcy stays, and the limitations of the research tools made available by his law firm with which he and Mr. Schwartz were both associated. Mr. Loduca also violated Rule 11 by swearing to the truth in the affidavit while he had no basis to do so. Mr. Schwartz walked into his office, presented him with an affidavit that he had never seen in draft form. Mr. Loduca read it and signed it under oath. A cursory review of his own affidavit would have revealed that one of the cases could not be found. Many of the cases were excerpts and not full cases, and reading only the opening passages, for example, of Varghese, would have revealed it was inconsistent and nonsensical. Yeah, even I picked up on the Varghese case in the first paragraph. Literally the first 3 sentences reveal that it's a fake case. Further, the court directed Mr. Loduca to submit the April 25th affidavit, and he lied to the court when seeking an extension. It was Mr. Schwartz that was on vacation, not Mr. Loduca. This is Mr. Loduca's bad faith. Mr. Schwartz violated Rule 11 as he testified at the hearing when he looked for Varghese but couldn't find it, yet did not reveal this in his April 25th affidavit. He also offered no explanation for his inability to find Siefring. Poor and sloppy research would merely have been objectively unreasonable, but Mr. Schwartz was aware of facts that alerted him to the high probability that Varghese and Siefring did not exist, and consciously avoided confirming the fact. His subjective bad faith is further supported by the untruthful assertion that ChatGPT was merely a supplement to his research. It was the research. The Levidow firm is jointly and severally liable because that's the rule of law. Although, of the people at the hearing, based on the transcript, I felt that the most sincere speaker was the representative of the firm, the owner of the firm, who was ready to take responsibility as necessary. Rule 11, sanctions are meant to deter, not to punish. The court concludes that a penalty of $5,000 paid into the registry of the court is sufficient, but not more than necessary to advance the goals of specific and general deterrence. So within 14 days, respondents shall send, via first class, a letter individually addressed to Plaintiff Roberto Matta that identifies and attaches this opinion and order, a transcript of the hearing, the June 8th hearing, and a copy of the April 25th affirmation, including the exhibits. The same for the judges falsely identified as the authors of the fake opinions, and then also a letter to this judge, Judge Castel, explaining their compliance with those requirements. And so that was June 22nd. And the same day, the same judge issued a dismissal of the case. So the ChatGPT respondents were on the plaintiff's side. So now Avianca, the defendant, wins the case because, hey, the statute of limitations was not told by the Montreal Convention. Go figure. Sometime between 11 p.m. and 1 a.m., an employee of Avianca struck Mr. Matta on the left knee with a metal serving cart, resulting in his injury. He sued for carelessness, recklessness, and negligence. The injuries were grievous and painful, including unspecified damage to his nervous system that has required medical treatment and prevented him from working. So they dismissed the case because he did not sue early enough. Now, Mr. Matta might have a claim against his attorneys now, and they might want to be exploring with their own insurance carrier whether he's going to make a claim against them. If he hasn't already consulted with a different attorney, maybe one familiar with suing attorneys for malpractice, that would probably be best for Mr. Matta. I'm not sure if he would have been due any money. You don't necessarily get a whole lot of money because you accuse an attorney of malpractice or anything like that. But if he was due a $2 million award or something, and this was the thing that prevented it, then yeah, he's going to be talking about a settlement with an attorney's malpractice carrier or the attorneys themselves. Yeah, this is a bit of Schadenfreude. This is the latest round of attorneys running headfirst into the brick wall of technology. I admit I've used ChatGPT to ask some off-the-wall questions, including legal questions, never with client confidential information, but, I've asked it, what's the law on this? Except I don't turn that in as my homework. I don't turn that in as my legal brief. I asked it what are the bases for motions to quash in the type of cases that I work on, where subpoenas are filed before the plaintiff is before the defendant is identified. So these John Doe cases, did I miss anything? I filed a bunch of these motions to quash. Have I missed anything? And it came up with 7 different very good grounds for motions to quash. Not grounds in my case, but grounds that if I had one of those grounds, I would be able to use that. So it was very nice to see that it had a pretty good summary. And what you should do if you are using something as primitive as that is use it as a secondary source. Use it as a launching pad to get more information. Now I had 7 paragraphs of 7 different grounds to research, and I could go type those into a real search engine, a real legal search engine like Westlaw or LexisNexis or Fastcase or Casetext or a dozen other ones that are out there that all work fine. And you'd be able to find something on those grounds and find case law to support or not support. And then instead of citing cases that were wholly made up by a text generating ChatGPT engine, you'd be getting legal research that you could actually turn in as your work. Or maybe your legal research will verify that your client has no case and you should be dropping the case as soon as possible to limit the damage to you and your clients. Anyway, that's the conclusion of that matter, unless there's going to be some lawsuit between Mata and his attorneys, which I doubt. I have a feeling that there's been enough talk about this, and they'll get this resolved behind the scenes if there's anything left to resolve. So let me know your thoughts. Did this teach you about how lawyers are sometimes ignorant of technology? Did it teach you about how the judge responded to this potential for fake cases? I learned a lot, and I'm a lawyer. So this is great. That's why all the other lawyers in the world are watching this case too, because we want to see how can we expect the judge to handle the situation. What was it about this situation that was bad? It was the lying. It was the false affidavits. It was the lack of diligence. Nothing to do with the accident of using ChatGPT once. It was the negligence of doubling down, or maybe even the intentional wrongdoing or misconduct of taking the simple mistake, the admittable and understandable and funny mistake, and turning it into sort of the basis for more action, for sanctions in court. Let me know what you think in the comments below.